So this is my judgment. This is my judgment. The claimant commenced this suit by way of complaint and other accompanying processes filed on the 14th of May 2019 and asked for the following reliefs as contained in his amended statement of facts against the defendant. Number one, the sum of $237,315.6668 being differential in salary and what is entitled to at the prevailing exchange rate of Naira to dollar from 2010 till February 28, 2019, clients use Central Bank of Nigeria rate for all payments. Number two, the sum of $13,66 being the unpaid commission in dollars as at 2016 to 2021 due from contract negotiated on behalf of the defendant as agreed by a letter dated 3rd May 2018. Number three, sum of 5,071,400 Naira and 71 kobo being the unpaid commission in Naira as at 2016 to 2021 due from contract negotiated on behalf of the defendant as agreed upon. Number four, an order for payment of salary from 2010 till 2021. Number five, a declaration that the claimant is entitled to present and future commissions from businesses secured on behalf of the defendant which are ongoing. Number six, interest on the respective sums at the rate of 20% per annum from 2016 until final payment. The defendant, upon being served with the initiating process, entered appearance and filed a notice of preliminary objection, but did not file any defense. However, after listening to the objection, the notice of preliminary objection was dismissed by the court, and the defendant counsel thereafter filed a notice of withdrawal of appearance of counsel on the 13th of August 2020. Case of the claimant. From the pleading filed by the claimant and his testimony, he was employed by the defendant as a field engineer stroke representative by a letter dated 11 September 2001. That at the time of his employment, his salary was 30,000 Naira US dollar gross per annum, which is later reviewed upwards to 42,000 US dollars in November 2005. That between October 2001 and November 2010, the defendant paid the claimant's salary in US dollars. It was stated by the claimant that the defendant was paying his salary in dollars until between March 2006 and November 2010, when he started paying his salary partly in dollars and Naira, when the exchange rate was $1 to 150 Naira. The monthly salary was 3,500 US dollars and 147 Naira respectively. The defendant unilaterally decided to pay the claimant's salary entirely in Naira without any review or amendment of the contract of employment. That when the defendant decided to pay the salary in Naira, the understanding was that it should be based on current exchange rate, so the value of the salary would not be diminished. According to the claimant, the defendant, while paying his salary in Naira, has continued to use a lesser exchange rate of $1 to 150 Naira instead of the official current exchange rate of $1 to 306 Naira. Claimant also averred that at the time of the commencement of this action, the exchange rate was $1 to 306 Naira, but on the 24th of April 2022, it was $1 to 415 Naira on the Central Bank of Nigeria website. Claimant stated also that he had a separate contract with the defendant to earn 5% commission on new businesses introduced by him by a letter dated 3rd May 2008, and the claimant, by reason of the said contract for payment of commission, brought several clients to the defendant. The defendant continued to pay the commission to the claimant until 2016, when it unilaterally stopped payment. According to the claimant, he is still in the employment of the defendant at all material times, but his salaries, the differential in exchange rate, and his commission have not been paid. Trial. Trial commenced on 21st of June 2021, where the claimant CW1 testified by adopting his witness statement on oath dated 14th May 2019 and tendered the following documents as exhibits. Exhibits KCD 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, A and E, KCD 13, 14, 15, 16, and KCD 17. The defendant was not in court to cross-examine CW1, even though it was served with a hearing notice, and CW1 was thereafter discharged. CW2 also testified on the 1st of December 2021 and tendered the following documents. Exhibits KCD 17, 18, 19, 20, 21, 22, KCD 23, 24, 25, 26, 27, KCD 28, 29, KCD 30, 31, A1 to 47, and 32, A1 to 64. The defendant was not in court to cross-examine CW1, and the witness was also thereafter discharged. The matter was then adjourned for adoption of final written addresses, since there was no defense filed on behalf of the defendant. However, the defendant did not file any final written address, but the claimant did. Claimant's final written address. The claimant's final written address dated 29th of April 2022 was filed on the 4th of May 2022, wherein 3 issues for determination were submitted to it, and I quote. Number 1, whether the claimant has proved his entitlement of 5% commission on businesses brought into the defendant's company. Number 2, whether the claimant has proved his entitlement to salary differential from 2010 to 2019. Number 3, whether the claimant is entitled to the payment of the odd salary from 2019 till date. The Learned Counsel on behalf of the claimant submitted on issue 1 that there is a contract for payment of 5% commission by the defendant to the claimant on secured jobs or businesses as stated in Exhibit KCD 13. Counsel also submitted that there is also before the court unchallenged evidence that from 2016 to 2021, no commission has been paid by the defendant. That improved the contract and invoices paid by a major client, Total Group, brought in by the claimant, exhibit were tendered by an official of the company, CW2, who testified by virtue of a subpoena at testificandum. Counsel refer the court to exhibit KCD 17 and 18, which are a contract between Total E and P Nigeria Limited and Petrolink International Limited, the defendant, that exhibit KCD 31A 1 to 47 and 32A 1 to 64 are the payment advice invoices made by Total as stated in evidence by CW2. That from the above mentioned, claimant's counsel submitted as follows: that there is a subsisting contract for the payment of commission independent of the contract of employment. The claimant brought in clients to the defendant company. Prominent among them is Total Group, made up of Total E and P Nigeria Limited and Total Upstream Nigeria Limited. And the said contracts are running for which jobs are done, data services, call orders are made, invoices are raised, and payments made, as evidenced by payment advice. Testimony of CW2 was referred to as an official of Total E and P Nigeria Limited under subpoena gave evidence as CW2, confirming the existing contracts and call orders, referring to exhibit KCD 17, 18, 19, 20, and 22, and submitting further that jobs were done and payment was made. That the payment advice on the executed contract from 2016, 2021, and evidence as shown by exhibit KCD 31, A1 47, and KCD 32A1 to 64, that what is due to the claimant based on the 5% commission has also been shown by exhibit KCD 31A 1 to 47 and KCD 32A1 to 64 for the dollar and naira respectively. That exhibit 13 clearly shows that the claimant is entitled to the commission. Council also referred to the case of Afolabi and Governor of Oyo State. The suggestion supplied to submit that a breach of contract is committed when a party to the contract without lawful excuse fails, neglects, or refuses to perform an obligation he undertook in the contract, or either performs the obligation defectively or incapacitates himself from performing the contract. The council submitted on issue 2 that the claimant is still in the employment of the defendant as evidenced by the letter of employment, exhibit 1. The submission of counsel that the claimant's salary was denominated in dollars, but the defendant stopped payment in dollars and started paying in naira. That exhibit 12 is an email in which the claimant demanded the differential in the dollar to the naira salary payment. And exhibit 8 is the computation of the differentials. Counsel also submitted on issue 3 that there is uncontroverted and unchallenged evidence that the claimant is still in the employment of the defendant. Counsel further submitted that as long as his employment is subsisting and has not been validly terminated, the claimant is entitled to his salary, that this is an appropriate case to make a declaration for the entitlement to the salary and an order directing the defendant to pay the salary from 2019 till date. Another counsel for the claimant in his further submission to the court on the questions raised by the court on 25th of July 2023 contended that the interest claim on the unpaid salary would be inferred by the court, even though there is no express agreement to that effect. The other counsel considered also that statement of account of the claimant from 2010-2019 is not brought before the court, even though it was from December 2010 that the problem started. Counsel, however, argued that the claimant has presented his computations and email correspondence, exhibit KCD 8 and KCD 12A to E, to show the salary differentials. Opinion of the court. Upon careful consideration of the pleading filed by the claimant and the evidence adduced, as well as the submission of the learned counsel for the claimant, I will adopt the 3 issues as formulated by the claimant, which are as follows. And I quote, number 1, whether the claimant has proved his entitlement of 5% commission on business brought into the defendant's company. Number 2, whether the claimant has proved his entitlement to salary differentials from 2010-2019. Number 3, whether the claimant is entitled to the payment of the old salary from 2019 till date. As it was earlier stated, the defendant often been served with initiating processes, only entered appearance and filed a notice of preliminary objection, but did not file any defense. Hence, the suit appears undefended. However, the law remains settled and the same, that whoever desires any court to give judgment as to any legal right or liability, depending on the existence of fact which he asserts, shall prove that those facts exist. Equally, when a person is obliged to prove the existence of any fact, it is said that the burden of proof lies on that person. The claimant's claim is basically for entitlement, and in law, claims for entitlement being monetary claims are a claim for special damages, and the burden thus lies on the claimant to prove his specific claims. In other words, it is the duty of the claimant who asserts the existence of a legal right to prove that those facts exist. See the case of VP Industry Limited and Coca Industry Limited. The position of the law is that evidence ought to be laid before an award for special damages is granted. And to succeed in a claim for special damages, it must be claimed specifically and proved strictly. And the court is not entitled to make its own estimate of such claim or engage in logical deduction. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. See the case of NNPC and Clipton Nigeria Limited, Wangu and FBN PLC. The claimant in his relief number 2 has asked for the sum of $28,113.66 as his unpaid commission from 2016 to 2021, due from contracts negotiated on behalf of the defendant as agreed by a letter dated 3rd May 2008. I observe that the claimant's issue number 1 is distilled from the above relief. From the pleading of the claimant and his testimony, he averred that, aside from his contract of employment, he had a separate contract with the defendant to earn 5% commission on new businesses introduced by him by a letter dated 3rd May 2008. And according to the claimant, he has, by reason of the said contract for payment of commission, brought several clients to the defendant, paramount among which is Total Group made up of Total E and P Nigeria Limited and Total Upstream Nigeria Limited. Claimant also averred that the said contract for payment of commission is ongoing and the commission is payable as long as there is execution and payment. Claimant further stated that the defendant continued to pay the commission to him until 2016 when it unilaterally stopped payment. That the amount paid to the defendant by Total Group is $562 $273 and 101 million naira, and the calculated 5% commission of $562 is $28,000, and the 5% commission of 101 million naira is 5,071 naira. It's clear, as it was rightly submitted by the claimant, that Exhibit 13 shows that there is an agreement for payment of 5% commission by the defendant to the claimant on secured jobs/businesses as stated in the said exhibit. CW2, who is a staff for Total Group, confirmed that Total Group had a contract with the defendant for the provision of well data, secure extranet and intranet services, and invoices were paid by the Total Group to the defendant. Exhibit KCD 17, 18, and 20 also indicate that there was a contract between the Total Upstream Nigeria Limited and the defendant for the provision of well data, secure extranet and intranet services. And Exhibit 21 to 30 are call-off orders, purchase orders, and call-off contract. Meanwhile, payment advice on the executed contract from 2016-2021 are shown by Exhibit KCD 31A1 to KCD 47 and KCD 32A1 to KCD 64. It is tried that where evidence given by a party to any proceedings was not challenged or controverted by the opposite party who had the opportunity to do so, is always open to the court cease of the proceedings to act on the said unchallenged evidence before it. See the case of Odulaja and Haddad. Citation supplied. From the foregoing evidence, therefore, there is no doubt that the claimant has been able to prove that there is an existing contract between him and the defendant for the payment of 5% commission, and the claimant brought in clients to the defendant company where data services were provided, call orders were made, invoices raised, and payments were made to the defendant by the clients introduced. Rather from the above, claimants reliefs number 2 and 3 are hereby granted, and his issue number 1 relating to those reliefs is accordingly resolved in his favor. Improve the claimant's relief number 1. It was about that he was employed by the defendant as a field engineer by a letter dated 11 September 2021, 2001, Exhibit KCD1. At the time of his employment, his salary was $30,000 gross per annum, which was later reviewed upwards for $2,000. It was also stated by the claimant that the defendant was paying his salary in dollars until between March 2006 and November 2010. when it started paying his salary partly in dollars and naira, when the exchange rate was $1 to 150 naira. The defendant unilaterally decided to pay the claimant's salary entirely in naira without any review or amendment of the contract of employment. But when the defendant decided to pay salary in naira, the understanding was that it would be based on current exchange rate. According to the claimant, the defendant, while paying his salary in naira, has continued to use a lesser exchange rate of $1 to 150 naira instead of the current exchange rate. Now, it can be observed that the employment letter of the claimant, Exhibit KCD1, indicates that further conditions of the employment were attached to the letter, but the said attachment is not produced before the court. I also observed that Exhibit KCD6 is the evidence of salary review in dollars in 2005. Meanwhile, Exhibit KCD7 shows the salary review in local currency in 2006. Exhibit KCD8 is a computation made by the claimant on salary differentials, while the total salary differential was calculated as $197,000, while the interest was $40,000. Additionally, Exhibit KCD11 is the claimant statement of account from 31st of January 2006 to 3 of December 2010. Exhibit KCD12 is email correspondence, mostly between the claimant and the defendant. And on the email of 6/6/2015, the claimant demanded for salary increase, and it was stated by the claimant that his last salary increase was in 2010, but it appears that the document showing that salary increase in 2010 is not produced before the court. It's also shown on the email of 23 August 2018 sent by the claimant to Mr. J. Horton, defendant's Vice President Finance, thus, and I quote, "My unpaid salary amount as at August 2018 is $182,000. Unpaid salary is $155, and interest over the years is $27,000 unquote. Similarly, on the 21st of September 2018, Mr. J sent an email to the claimant as follows, and I quote, I quote, "Hi, Kenneth. You have been paid all your salary to date. There's none outstanding. And as 1st January 2018, commission is no longer being paid throughout the group. You've been advised of this. There is a profit share available, and I will shortly forward to you a year-to-date analysis of Nigeria's profitability based on global sales. Kind regards, J. Horton, Vice President Finance, Petrolink International Limited," unquote. Claimant also presented Exhibit KCD15, which is a computation made by him about his unpaid salary from March 2019 to May 2021 to the tune of $276,000. As it was earlier stated, this is a claim for special damages, which has to be specifically pleaded and strictly proved. Although the claimant's evidence appears unchallenged and uncontroverted by another pleading and should be deemed admitted, given that the defendant entered no defense in this case, but these are not absolve the claimant from proving his case. Even though the claimant has presented a statement of account, but I'm not being able to see from the said statement of account, Exhibit 11, how much salary was partly paid in naira and dollars simultaneously to the claimant by the defendant, and how much remains unpaid, if any. Even at that, the claim of the claimant for his salary differential under Relief 1 was from 2010 to 2019, whereas the statement of account only covers the period between 2006 and 2010. I think it's not just good enough that the claimant only presented his statement of account from 2006 to 2010, when there was even no problem with his salary, and ignoring to present the statement of account from 2010 to 2019 when the problem started. I expect that the statement of account between 2006 and 2010 should be brought before the court to enable the court to see how much naira was paid or not paid and how the claimant was changed. Suffice it to say that In the entire plea and evidence presented by the claimant, there is no evidence showing the channel through which the claimant was paid his salary, either in naira or dollars, between 2010 and 2019. And the bank statement of account exhibit KCD 11 presented did not show that either, because it only covers the period between 2006 and 2010. On this score, therefore, I do not think that exhibit KCD 11 is of any help to the claimant as far as the proof of payment or non-payment of a salary with regards to his relief 1 is concerned. Claimant has also, in exhibit KCD 8 and 15, made his own computation of his salary differential and unpaid salary, but the claimant did not refer the court to the instrument or document that conferred the said computation, or refer to a document upon which the computation was based. To prove an entitlement as in the circumstances of this case, the claimant must refer the court to the exact instrument or document that conferred the entitlement. See the case of Mr. Mohammed Dungus and ENL Consortium Limited, citation supplied. In the instance case, therefore, the claimant is expected by law to plead and support his claims by credible and convincing evidence, and that evidence should preponderate before those claims can be acceded to by the court. And where he fails to discharge the honors, his claim is bound to fail. See the case of Hamza and Kuri. Similarly, the claimant in his email of 23/8/2018 claimed that his unpaid salary is 155,000 USD, and interest over the years is 27,000 USD. Yes, equally in his solicitor's letter, Exhibit 14, claimed for 197,000 USD as differential and interest of 40,000 USD. The interest claimed appears to be a prejudgment interest, and the law is that prejudgment interest on a debt or loan can only be awarded where there is sufficient evidence of an agreement between the parties that such interest will be paid. The agreement should contain details such as number A, rate of interest, date of commencement, debt due, whether weekly, monthly, yearly, or other specified period. However, there's no such agreement expressed or implied placed before the court on the payment of that interest in the event of failure to pay the claimant's salary. I think that computation is just a figment of the claimant's imagination. See the case of Ekpeyong and Young, Barclays Bank and Abubakar, Himma Merchant and Aliyu, VP Industry and Coca Industry. Arising from the foregoing, therefore, I'm unable to be persuaded that the claimant's claim for differential in salary and non-payment of same has been proved by credible and convincing evidence. Consequently, claimant's reliefs 1 and 4 are hereby refused, or relief 5, which is for a declaration that the claimant is entitled to present and future commissions from businesses secured on behalf of the defendant, which are ongoing. I think we're not yet there, as there's no evidence yet that payment advice was raised and payment was made to the defendant. Exhibit KCD 13 says that commissions will be paid at the rate of 5% of the amount invoiced to the defendant's client, and the commission will be payable on receipt of the funds from the said client. The relief is accordingly struck out for being premature. Relief 6, which is a claim for prejudgment interest, will also have the same fate with earlier claim on prejudgment interest, and is also accordingly declined. All said, the claimant's case only succeeds in part, and for the avoidance of doubt, I hereby make the following orders. Number 1, that the sum of $28,113.66 shall be paid to the claimant by the defendant, being the unpaid commission in dollars as at 2016 to 2021, due from contracts negotiated on behalf of the defendant as agreed by a letter dated 3rd May 2018. Number 2, the defendant shall also pay the claimant the sum of 5,071,471 kobo, then the unpaid commission in Naira as at 2016 to 2021 due from contracts negotiated on behalf of the defendant. Number 3, claimant's reliefs 1, 4, and 6 are refused and are hereby accordingly dismissed. Number 4, relief 4 is hereby struck out. Number 5, judgment shall attract 10% post-judgment simple interest per annum until it's fully liquidated.
We thank you, my lord, sir. We are very grateful. That is a judgment that shows a lot of industry. We are grateful to my lord, sir.
Thank you.
We would be asking for 20,000 naira cost.
I even awarded cost. Too.
Okay, my lord.
I ordered cost. I didn't. I said judgment is entered accordingly with a cost of 1 million naira against the defendant in favor of the claimant.
As the companies, we are much obliged to the court, sir.
Thank you.
Thank my lord, sir. And thank you, Aja, too.
Thank you, sir.
And if you want to contest the judgment with regards to the part that was not granted to you, we're looking forward to see what the Court of Appeal will say on that. Yes.
Thank you, my lord, sir. It's just the declaratory part, since it's for the rights of parties that were new for them. But we are, I think it's a good one. We thank my lord, sir.
Yes, you can still contest it if you want the other claims.
No, it's okay, my lord, sir. Thank you, my lord, sir.
Thank you.
We don't know, my lord, when we'll be able to have a copy of the judgment.
Yes, number one, I'm going to, we're going to post it online.
Okay, man. Okay.
And number two, for the hard copies, I'm going to send it to Haja. So I will collect from Haja. The hard copies will be sent to Haja. We collect from Haja, and the soft copies or copy, you'll get it on our portal, God willing. Okay,
that would be nice, my lord, sir. That would be very good. We are much obliged.
Thank you so much, Doctor, and your colleague Yunus.
Yeah, yes, thank you, sir. Thank you, my lord.
Thank you so much. Thank you, Haja.
Yes, my lord.
Yes, well done.
Thank you, sir. Madam, I'm so sorry I joined late. I went to the toilet.
It's okay. You don't need to say it too. It's okay. Okay, yes, Haja.
So I hope my lord will be coming back to Lagos soon.
Yes, but I think we'll be finishing in October.
Okay.
That means you are not going to sit in October.
I don't know.
Maybe I should go and learn work. Or this one that we are coming every.
Because we are still writing judgments. We are still writing our judgments.
The judgment will be delivered in October, 3 months, 90 days.
Yes, some in October, some in September.
Okay. Yes. That means your lordship will not be going for vacation.
Yes, we'll not be going for vacation.
Oh.
Yeah, we'll not be going for vacation.
But
maybe I will go after the election petition matters.
When will my lord now come back to Lagos?
I'll come back.
They will tear me apart too.
No, they won't tear you apart. You know, one thing is that Lagos cases won't end.
It can never end.
It can never end. It can never end. It can never end. So just do what you'll be able to do and leave rest to God.
Yeah.
But I will still try my best to see that I come back as soon as we are done with the election petition matters.
Okay, my Lord. God will give you strength.
Thank you,
Amen.
inshallah.
Take care of yourself, my Lord. Take care of
Thank
your
you,
health too.
Thank you, Doctor.
Right.
I'm grateful. I say goodbye to you and Hajia.
Thank you. Bye-bye.
So we see you later. Thank you. Bye-bye.
Okay, I will call you later, sir.
Okay.